think so. She's got a really good defense team. They're experienced trial lawyers. I think if they're comfortable with the 7-month time period, I don't question whether or not they're going to be able to put a case together for her.
Well, I've said some bad facts just in the lead up to introducing you, but what's the uphill battle that the prosecutors have? Because from this end of things, it looks like it's a slam dunk.
Right. I mean, everything always looks really bad. You know, what gets put in the press, what gets put out at a preliminary hearing. But Kouri still hasn't had a chance to tell her side. That will come at trial. I think the prosecutors are going to have a real problem in this case, proving that she got the fentanyl and how she administered it if she got it to Eric. They don't have any, real theory to fall back on that. And I think that's going to be a really strong point in her defense. And I think the same is true for the attempted murder charge. A lot of this is circumstantial. It's what the prosecution maybe believes happened, but their theory and being able to prove it beyond a reasonable doubt are two very different things.
So you just piqued my interest when you said she hasn't been able to tell her story yet. Are we going to hear some surprises at trial?
That's up to her current defense counsel and what they want to put forth as a defense in this case. So I don't want to speculate, but I do think that there's more to be told to the story in favor of Kouri.
So can I ask, and I have a feeling I know your answer, but can I ask, why'd you withdraw?
I can't say anything more than what was contained in the pleadings. There was a conflict that arose within the civil estate case that conflicted the entire firm, and they told us we were all out.
Okay, so then what about the letter, that business? I think they called it the walk the dog letter because that's what it said at the top. But you contend that letter was addressed to you. And if that's the case, is your point that would make it attorney-client privilege and no one should have been able to read it if it was in her cell?
That's right. I filed a motion to suppress on this letter before I withdrew from the case. And we previously litigated the contents of that packet. And Kouri and what the prosecution's alleged is that this letter was part of those documents in some sort. And those documents, the judge said, were not only privileged, but also potentially work product. And so the basis of my motion to suppress the letter essentially was, look, if it's part of it, then this letter should have been suppressed too. They shouldn't have been able to take it out, publish it to the press, etc. Now, what her current defense counsel decides to do with it is ultimately up to them.
And then real quickly, was it that she contends this is a manuscript for a book and wasn't an instruction to get her mom to get her brother to lie for her?
I'm not going to put facts out there. I'm not sure what, when they renew the motion, what they're going to argue. But the judge previously ruled that there was no witness tampering. He denied the state's motion as it relates to that. So, to go out and say she was trying to entice people to lie when there's been a finding already that she wasn't attempting to witness tamper, is problematic for her, and it never should have happened in the first place.
Well, I sure am happy that you joined us for this exclusive interview, Skye Lazaro. Thank you, and I look forward to seeing you again soon.
Yep, good to see you, Ashley. Thanks for having me.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.